Hello, I'm Peter Afrasiabi, a lawyer with the law firm of One LLP, and today's ethics presentation is the ethics of attorney-client transactions, how to avoid tripping the wires. Let me start and tell you a true story, true fact pattern. Lawyer's representing his client in deep, protracted litigation. It's a massive battle over some real estate, and the client, which is an LLC run by a single individual, gets well behind the lawyer in fees. Client owes about $1 million in legal fees. The client comes to the lawyer and says, hey, I need you to keep going. We need to win this case. Will you stay on? Lawyers, I need to get paid. As we all know, we need to get paid. Client says, I'll give you a deed of trust and promissory note on the subject piece of real estate in the litigation. Lawyer says, okay, fine, but you have to have independent counsel and go get independent counsel because I can't enter a transaction with you unless you have independent counsel. Client gets independent counsel, lawyer negotiates with the independent counsel, a promissory note and deed of trust is signed. The client, LLC, the owner of the LLC, signs even an attestation in the promissory note that he had received independent counsel ahead of the transaction. Documents are signed, lawyer continues litigating. Client goes deeper and deeper into the hole, and then one day the client fires the lawyer. The client then turns around and sues the lawyer to void the transaction. Lawyer says, I had independent counsel. I negotiated with independent counsel. What could possibly be wrong here? Trial court judge says, it's not for summary judgment. This is for a jury to decide whether you, the lawyer, used undue influence to get that promissory note deed of trust signed. True story. It's a client I represented, the lawyer that is, in a case. And so this ethics presentation today will talk about the tripwires that exist in terms of anytime you enter a transaction with a client. And this comes up in myriad circumstances and contexts. The rules are somewhat counterintuitive because they run against the grain of normal contract rules that we as lawyers are used to in terms of contracts for our clients, entering contracts with other clients. But they are very, very dangerous rules and they can be very, very punitive. We'll come back to that case and what happened, but that fact pattern is not necessarily atypical given the law and the cases you're going to see. And so this ethics presentation should well prepare you to make sure that if you ever do enter some sort of a transaction with your client where you take a pecuniary or financial interest in any of the client's property, you do it in the most protected way possible so that you can avoid being subjected to claims down the road that you did something improper. So we're going to start today by walking through the governing rules of professional responsibility. We're going to focus primarily on California Rule 3-300. It's almost identical to the New York Rule 1.8, the ABA Rule 1.8, and other jurisdictions have the near identical rules. So I'll use 3-300 really as a shorthand for this rule that governs attorney-client transactions regardless of what jurisdiction you're in. We'll walk through the three aspects to 3-300 that exist and the requirements so that you can do your best to make sure you never find yourself on the receiving end of a claim from a client that you tripped an ethical wire. And then we're going to walk through 8 specific case studies and look at 8 specific scenarios that are actually very common and recurring where lawyers enter clients with transactions, and whether you know it or not, your transaction is being subjected to 3-300. So let's get started and focus on these issues. Number one, the attorney-client transactions often seem unlikely to a lawyer. And what I mean by this is that you may have some massive joint venture real estate deal with a client where you're not really a lawyer anymore. You're not advising the client. It's a former friend or a client. You're now doing a new deal. And so you think you're just off the practice of law doing a joint real estate transaction. Maybe not. So the point being, these transactions are much more common than you think in terms of being regulated by the attorney ethics rules. Many of them, in fact, trigger these rules governing the propriety of transactions. And the common scenarios where these occur that particularly may not be thought of by you are getting stock in a client, giving a loan to a client, or renegotiating an existing fee agreement once you're down the road of litigation. And the upshot of all of this is that, as you will see in the cases we work through, is that all too often lawyers go from being investors in a client project to insurers of that project, which is not what any of us ever want to do. So over the next hour, you will get the lowdown on how to avoid ever becoming an insurer and to remain an investor. The governing rules, as I mentioned, are these governing rules from California, the ABA, but we also have state fiduciary duty rules that attach, tort law that is. And so violations of these ethics rules can be the predicate for a breach of fiduciary duty claim also, and we will talk about that on the back end a little bit. Let's get straight to California Rule of Professional Responsibility 3300, and here's the rule in all its glory. A member shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless each of the following requirements has been satisfied. A, the transaction or acquisition and its terms are fair and reasonable to the client and are fully disclosed and transmitted in writing to the client in a manner which should reasonably have been understood by the client. And B, the client is advised in writing that the client may seek the advice of an independent lawyer of the client's choice and is given a reasonable opportunity to seek that advice. And C, the client thereafter consents in writing to the terms of the transaction or the terms of the acquisition. If we flip to the next slide, we'll see ABA Rule 1.8 and New York Rule 1.8, and they are essentially identical in language and almost identical to the California language. Again, it's the same requirement that if you're to enter a business transaction where you knowingly acquire some sort of an interest adverse to your client, you can't do it unless it's on terms which are fair and reasonable to the client and fully disclosed and transmitted in writing in a manner reasonably understood by the client. Again, that's the same as 3300A. The client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel on the transaction. And C, the client gives informed consent in a writing signed by the client to the essential terms and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. These rules are specific and serious, and they are not ones where you have form over substance, where you can make technical violations or you can be within the spirit of it, but maybe you didn't check a box. Not checking a box or hitting the button means you lose. And so on the next slide, you can see some quotes from some case law dealing with really what are the overarching governing principles. The case law I've taken from California, but there's similar cases in all jurisdictions. The first one really starts with the principle that the relation between attorney and client is a fiduciary relationship of the very highest character and binds the attorney to most conscientious fidelity, uberrima fides, Latin meaning most abundant faith. You also have a more recent case from the California State Bar, the Eschwig case, which says, quote, in civil cases, there are no transactions which courts are more jealous and particular than dealings between attorneys and their clients. That's a critical proposition because what one finds in this body of law is that courts will look for any way to undo a transaction, any way to void a transaction at a client's request, and will most jealously, and one can't stress most jealously, seek to guard against those transactions and undo them. So the net result here, and this is the first major practice pointer, is that any agreement with your client that gives you an interest in the client's property generally must comport with 3300. So let's go to the next slide and start with the natural question you ask. But what about the engagement agreement? Do we really have to comply with 3300? Here, of course, the rules slightly differently, or it unfolds in a slightly different way. The original agreement is presumed to be arm's length, and 3300 generally does not apply to the original agreement unless the attorney, by nature of that agreement, secures a possessory interest adverse to a client. So the exception to that is contingency. If a contingent lawyer receives an interest in the outcome of the case, you're going to litigate the copyright case on contingency. You get 33% if you prevail. In the engagement agreement where you're getting that stake in the potential recovery down the road, that agreement is not subject to 3300 because the law has concluded that the lawyer is taking and shouldering the risk, and so 3300 doesn't apply. But there's a major exception here. If it's an hourly case and you are representing the client in litigation, let's say it's a copyright case again, and you're getting paid $350 an hour or whatever your rate is, and you litigate hourly, but you also put in that engagement agreement that you are entitled to some sort of a charging lien on the ultimate settlement or recovery in order to pay whatever's still owing you in terms of unpaid fees by the client, that transaction is subject to 3300, and that's from the massively important California Supreme Court case of Fletcher v. Davis. And so it's an important case, and it's one to stop and think about a little bit, because what it means is that a very standard term in your engagement agreement, you want to make sure you get paid down the road. You know that when you get to the point of settlement or judgment, the client may be behind you 1 or 2 months, and once the client gets the money, maybe the client doesn't want to pay you or wants to renegotiate how much they owe you. And that's obviously a terrible position for a lawyer to be in. We're all lawyers and business people. We understand that. We've been in that position. And so a very common reaction to that by lawyers in engagement agreements, and I've seen many in my representation of lawyer clients over the years dealing with this situation, is to have standard verbiage language in an engagement agreement that lets you just gain some level of protection. If you do that, the language is invalid, it's voidable at the client's election, and you're completely out of luck. The one thing to keep in mind also here is that if, regardless of hourly or contingency, if down the road, deep into litigation or deeper into litigation, you sit and renegotiate with a client, this triggers ethics concerns too, and we'll talk about it a little bit later, but the basic principle comes from the restatement, and that is that if a contract modification is made beyond a reasonable time after the lawyer has begun representing the client, then the client may avoid it unless the lawyer shows it's fair and reasonable. And this has been generally held across all jurisdictions. And so renegotiations, keep in mind, those are going to be subject to these ethical rules. In California, as we turn to the next slide, as is true in many states, there's actually a presumption of undue influence in terms of a transaction between attorney and client. Here it's as follows. It's from the California Probate Code, section 16004, and it holds a transaction between the trustee and a beneficiary which occurs during the existence of the trust while the trustee's influence with the beneficiary remains, and by which the trustee obtains an advantage from the beneficiary, is presumed to violate fiduciary duties. Now, it also says this doesn't apply to an agreement relating to the hiring or compensation of the trustee, i.e. the original engagement agreement. But post-original engagement agreement, then yes, there's a presumption of undue influence. So this is significant because what it means is you may well have a transaction that you prove to be just and fair, that may be very reasonable. The client may have made a lot of money and it may have been lucrative for the client. But you as a lawyer, when you're challenged in these transactions, are subjected to a presumption against you. And this is the first sort of staggering disconnect in terms of the ethical rules and the normal laissez-faire rules of contracts and contract bargaining and interpretation that we as litigators deal with for our clients all the time. In litigation, as we all know, contracts are generally enforceable, and the doctrines that allow one to get out of a contract, frustration, impossibility, impracticability, those doctrines which were fantastic and wonderful in law school and for bar exams, of course, in practical experience, find very little refuge in the law and are very, very hard and very, very rare. The general rule is a contract's a contract, one's word is one's word, a deal's a deal. You don't get out of a contract with any presumption that it's just invalid. This is the opposite world. There is such a presumption. You have some examples of cases I've given you here where courts have applied the presumption, such as the BGJ case in California, shifting the burden to the lawyer to justify the transaction and get out of it. So you not only do you have to comply with 3300, but you actually have to overcome this presumption. Now, there is a California case that's held in the context of a fee agreement, even an original fee agreement where the lawyer was taking a deed of trust to secure an hourly payment, that agreement, while subject to 3300, was not subject to the presumption because it was an initial fee agreement. And there's that last section, as you see in 16004. So you can be fairly sure, in California at least, that an original fee agreement isn't subject to a presumption, even if it's an hourly agreement where you put a charging lien. Of course, the problem with that is if you put a charging lien in an hourly agreement, presumption or not, you violated 3300 unless you comply with every single element of 3300, as Fletcher said. So the best advice one can give is that whenever you take any kind of an interest in client's property, initial agreement or not, presume 3300 applies and do your best to comply with 3300 and not have a problem, the exception being contingency agreements, of course. This now lets us go to the next slide, and let's go to prong 1 of Rule 3300, and that is this fair and reasonable disclosed in writing. And so the critical case here in California is a case called Fair versus Bakhtiari, and it's a case where the transaction was deemed fair and reasonable as a matter of law. In fact, it was very, very lucrative. But because there was no initial writing outlining the terms of the transaction to the client, the transaction was voidable at the client's election. And so here are the facts, because it's a fact pattern that you may find somewhat startling. 1989, you got a rich client that comes along and needs a lawyer for some legal help on some real estate investments and whatnot. Lawyer meets the client, helps the client as the client does some transactions and some dealings with some others on real estate. And they have an attorney-client relationship. Client then comes to the lawyer and says, hey, let's start some ventures together. I'll put up the money, you put up your legal expertise, I'll get 70%, you get 30%, let's do a deal. Client says, great. We're now a year later. The first one was 1989, we're now in 1990. And off they go with this sort of joint venture, all of which was an oral deal. So they've got this oral joint venture running, they're making investments, they're developing property. You fast forward a few more years and the lawyer actually now has left entirely the practice of law and is actually an employee of one of the LLC operating entities that was created for one of the joint venture ventures. And this goes on for several years actually, where they're making money, they're investing in real estate, they're splitting at 70-30, and life is fantastic. Of course, all things good things come to an end, it seems, in these cases. That's why we're talking today about the ethics boomerangs and the problems. And so you now are in 2001, a full 11 years after this oral joint venture real estate situation began, and there is a blow up between the parties, and this is not just metaphorical, it's literal. The case starts with the attorney suing the client for personal injuries for battery. Client responds with a 3300 claim that the entire joint venture is voidable because it was never outlined in a writing to the client as to the terms and conditions such that the client could consent. That's that first prong of 3300, of course. Court looks at it and the court concluded this was a very fair and reasonable deal. In fact, it was very lucrative. The client made out fantastically well. But because the lawyer didn't comply with 3300, as technical as it may be, the absence of a writing outlining the terms, because they had an oral joint venture, meant this was voidable at the client's election. The client elected to void it, and the lawyer was out on his 30% of the venture on an ongoing basis. The lawyer also claimed, well, what about equity fallback? I should get quantum merit, some sort of quantum merit recovery, which as litigators we're all familiar in normal contract litigation is sometimes a fallback position in equity one pleads. The court concluded, no, you breached 3300, you're not even entitled to a quantum merit recovery. So the massive practice pointer here is that in writing, advise the client to get an independent lawyer to advise it on whether the terms are fair and reasonable and to advise it on the pros and cons of the transaction. If the client is not using an independent lawyer, though, then you have to lay out in a writing, not orally, but in a writing, the pros and cons of the transaction. And you must do it, the case law has been clear, in a manner that is most adverse to yourself and most advantageous to the client. In other words, you can't just outline the pros and cons in some way that's slanted in your favor. You must act as if you're an adversary of your own self and point out everything to the client in terms of why this is a bad deal for the client and why it's so great for you in order to fully apprise the client. The best practice is to get the client to use an independent counsel, because if they get independent counsel, then you, the lawyer on the transaction, do not need to lay out the pros and cons of the transaction. That is the job of the independent counsel. And there's actually case law that has held repeatedly that once independent counsel is involved, you shouldn't be outlining the pros and cons because it gives rise to mischief. There's an independent lawyer who should be providing that duty to the joint client who is, for you, an adverse party on the transaction. This brings us to the next slide, which is factor 2, and that is advising the client in writing that they may seek independent counsel. Now, this factor, the best way to discharge this factor is to put it in a letter or an email in a writing to the client that they should go and get independent counsel, then have independent counsel negotiate, and then do the deal documents. If you don't do that, though, one case in California has held that when the deal documents themselves have a standard paragraph in them that references, I, the client, had the chance to get independent counsel, to negotiate with independent counsel, and I'm hereby entering the transaction freely and voluntarily, the BJG court has held that that arguably discharges the writing obligation under the second prong of 3300. And that was also a case, again, real estate, again, an oral joint venture. This is a case where there was an oral discussion about what they were going to do. There was later on a draft document put together, which was an operating agreement for one of the entities. And it had some representations in it that the lawyer had represented the client to get independent counsel, and the client had been so advised, and the court said that writing in the ultimate operating agreement that was subsumed within this oral joint venture would arguably satisfy the prong. Whether another court would agree with that, it's unclear, and the court only held that it arguably satisfies it. The court still bounced the transaction on the ground, like the other case we just discussed, that there was not a writing outlining the terms of the transaction to the client at its inception, and so that made it voidable at the client's election. So the critical lesson here is that if you're going to do a deal with a client, never, ever, ever do an oral one. We know that much. If you're going to do one, it must be in writing. Put everything in writing. Advise them to get independent counsel so that you can get on your way with your transaction. This brings us to factor 3, client consent in writing. It's a non-dischargeable duty. The client must consent in writing. So even if you meet 1 and 2, it was fair and reasonable, you told him to get independent counsel, you outlined all the terms, you advised him in writing that he could get independent counsel, he signed all the deal documents. If there isn't an actual specific consent in writing to the transaction, then the absence of that written consent makes the transaction completely voidable. And so in the oral agreement cases, yet again, you have situations where the client consented, agreed that he consented, even in the litigation said, yes, I consented. I never withdrew my consent. I always consented, but I gave oral consent. And the absence of written consent is fatal, and the transaction becomes voidable at the client's election. So as you can see, these are the 3 factors, and all of them circle around, as we get to the next slide, one major issue, and that is independent counsel. The safest course always in these scenarios is to have your client go to an independent counsel to represent that client and then negotiate with you on the transaction in which you're taking an interest in the client's property. And this is a statement from a California Supreme Court decision. It's Maltman versus State Bar. Specific recommendations by an interested attorney might inhibit rather than aid the client's effort to obtain objective advice. And so what that means is when giving or asking the client to get independent counsel, do not send it to a friend of yours. Do not advise which lawyer the client should go to, because if you participate in the selection of the independent counsel who is to negotiate adversely to you, courts can look at that as being, a button for concluding that the counsel was not really independent and that the transaction was potentially a sham. So the practice pointer, of course, don't send it to a friend of yours or to your brother-in-law or someone who's going to do you a solid and a favor and kind of just negotiate in a half-hearted way. Do it right. Make the client go find their own lawyer and then have a real robust negotiation to get there. That takes us through independent counsel and these 3 factors. And so now we can get ready to turn to looking at 8 specific scenarios where attorney-client transactions come about, the ethics implications in them, and how these tripwires are tripped and how you can avoid tripping them. Let's get moving then to the next slide, which is example 1, a charging lien on future recovery proceeds. Let's first of all address what is a charging lien. A charging lien is a contractual lien against proceeds or recovery. It's not automatic upon provision of services, but it's the right to be paid from a certain source if the specified events come to pass. So such as if there's a judgment or a settlement or a recovery or an insurance payout, I, the lawyer, then get paid, all the money that's needed to come current on the outstanding fees owed me. And so this is the Fletcher v. Davis case, which we alluded to earlier in the discussion. And there, it's a fascinating fact pattern. You have a client who's been locked out of his business by the landlord, and the client goes to an attorney and says, I need help. Attorney says, I can help you, and the client says, but I don't have any money, or I don't have enough money to pay you because we've been locked out of the business, and the assets that are inside the business are what we use to make money, and now we can't get at them. So we need you to help us get out from the landlord's, lockout. So client and lawyer orally agree, yep, let's go forward. The lawyer is going to get paid an hourly rate, and the client agrees that when the lawyer successfully saves these assets and proceeds, the lawyer will also get a charging lien on any proceeds to pay the lawyer the legal fees that the client won't be paying, even though it's an hourly deal, and also a bonus for the lawyer upon reaching a certain sort of milestone, and they had agreed to this. This was all oral. The lawyer then reduced it to a memorialization later, sent it off to the client. The client never actually executed it, it turns out. And as in many of these cases, the litigation went successfully for the client, but then it became unsuccessful for the lawyer when the client turned to the lawyer and said, we don't want to pay you the bonus, and you violated 3300. And the California Supreme Court concluded that if an attorney secures payment, and here's the key quote, of hourly fees by acquiring a charging lien against a client's future judgment, then it's an interest adverse to the client, 3300 applies. And in this case, because there was no writing and because those litmuses of 3300 outlining the pros and cons of the deal weren't done, the deal became voidable at the client's election. And so this means the client didn't have to pay the bonus, didn't have to be subjected to a lien on the recovery proceeds, leaving the lawyer obviously with a contractual claim for his hourly rate against an uncertain recovery pool, presumably. So it's a very, very common situation that lawyers find themselves in, wanting to get a charging lien, regardless of whether it's an hourly or a contingency case. But if you in an hourly case are going to do it, remember, you must comply with 3300. And again, the exception being for contingency, as we discussed earlier, it's not subject to 3300. And here you have the California State Bar Rule 2006-170 that actually explains how that's not the state of affairs for contingency cases. So let's go to the next slide, which is where clients assign the right to statutory attorney's fees. This is a common scenario in civil rights cases, especially where there's a statutory right to attorney's fees, but it's also common in intellectual property and trade secret contingency cases. Copyright, trade secret statutes have prevailing fee statutes for the prevailing party. Attorneys sometimes do these cases on contingency, and they want an assignment of the client's statutory attorney's fees rights. Now, this issue has been resolved by the U.S. Supreme Court, the California Supreme Court also, but attorneys can, in their original engagement agreement, secure an assignment of the client's statutory right to fees, which right belongs to the client, but that can be part of the deal in the beginning. And this often is very, very important for the attorney because, as you can imagine, many an attorney found itself in the position of litigating on contingency where there was a statutory fee award on the back end, and the client then decides that injunctive relief is wonderful and is willing to walk away from the whole thing, including any right to fees, and the attorney then is completely out of luck on the litigation. And so the result of this is that attorneys have gone and demanded in engagement agreements an assignment of the right to fees, and that's been affirmed as being a legitimate assignment that can occur. The question is, if it occurs in the engagement agreement, is it subject to 3300? And the answer, as you can see from the California State Bar Opinion Letter 1994-136, is that yes, 3300 applies. So if you are going to take that assignment of an attorney fee award to yourself in the original engagement agreement, you must comply with 3300. This is an area where I have seen in my practice many times over the years that it is not complied with well. It's a very standard boilerplate language that's in engagement agreements, especially for contingency lawyers where there's a statutory fee award, to work the assignment. And this is done because lawyers are familiar with the U.S. Supreme Court case, the seminal decision that allowed this, and the California Supreme Court case that's allowed it to. And so lawyers know they need to get the assignment. They get the assignment, they're comfortable, it's in the engagement agreement, and they forget that this is a transaction that is subjected to this additional 3300 overlay. So make sure you comply with 3300 on that. Let's now go to the next slide, and that's where you get a deed of trust secured by a note, promissory note, in order to pay the fees. And so this is a scenario of where a lawyer, this is a standard case, Hawk v. State Bar, lawyer meets with the client, tells the client, I'll do it for a flat $15,000 through trial. Client says, great, I'm willing to do it, but I don't have any money. Will you take a deed of trust and promissory note? And the lawyer says, yes, I will. And so the lawyer gets the deed of trust and a promissory note from the client. They proceed into litigation. The lawyer doesn't follow the 300 litmus test in terms of pros and cons and advising in writing. It's just an engagement agreement with a promissory note deed of trust. They go into litigation. The lawyer litigates for a while. Client then decides, I don't want to pay, and decides, you know what, that deed of trust, I'm not going to give it to you, nor the promissory note. And it then goes to litigation, and the court held that it's voidable at the client's election. That's Hawk versus State Bar. It's an important case to be aware of, because whether it's at the inception of the case or it's midstream, if you acquire that adverse interest, i.e. a secured deed of trust on a piece of client property, you must comply with 300. Let's just close the loop on the case we talked about in the beginning. My attorney-client who had been in a transaction where he took a deed of trust and a promissory note. And that was one, as you recall, where the attorney told the client, go get independent counsel. The client was a single member LLC. The client got independent counsel. Independent counsel negotiated with my attorney-client. The two negotiated, and they eventually signed a deed of trust and promissory note. The promissory note had an attestation in it that the client had secured independent counsel, and the client, on behalf of the LLC, signed that attestation in the document. The client, as I mentioned, later challenged, filed a lawsuit against the attorney saying it's void under 300 at my election because I never had independent counsel. And the attorney's reaction, of course, and as counsel for the attorney, our reaction was, of course you had independent counsel. Here's the person who it was. They negotiated with the attorney. Here's the email exchange. There was a negotiation. You had independent counsel. And by the way, you signed the deal documents noting you had independent counsel. The response of the former client was, I, the LLC, never had independent counsel. I had it personally in my capacity as an individual, not in my capacity as CEO. And when I signed that attestation, I didn't read it or pay attention to it. I didn't even know what it was. I thought it was standard language. The trial court concluded that belonged before a jury. It was not even subject to a summary judgment. And so a jury got to assess whether this independent counsel that indisputably negotiated on behalf of the entity or the person, the jury had to decide, was the entity getting independent counsel, or was the entity never getting independent counsel because the entity's CEO in his personal capacity was getting counsel? So when a case is then set for trial, you can imagine what that means. No lawyer likes to be a defendant in trial subject to a transaction where there's potentially presumptions of undue influence and a client saying you took advantage of me and you got all this money. Terrible position to be in. The case ultimately settled, as you can imagine. But it goes to show, even where lawyers think they do everything right, there's always potentially wiggle room. And so the wiggle room there was that the client created this artifice of who got the independent counsel, client as CEO or client as man. That distinction is one which, when we get to the end of this program and I give you some more practice pointers, is one that I have now learned in litigation firsthand, representing my client, how it can come about. And so there are things you can do to protect yourself against it in the deal documents and in the negotiations in terms of 300. But the major point from this is that there's always risk in these transactions. Anytime you enter a transaction with a client, even if you document and detail it perfectly, highly creative, highly aggressive people who want to find a way out may look for anything. And when you get put into a court setting, you may find yourselves before a busy superior court or federal district court that looks to the law that says we jealously guard these transactions and simply concludes it's inherently factual. We have to let a jury decide it. So let's now get to the example 4, which is the example of business transactions that are intertwined with case representation. This refers back to the BGJ case that we talked about earlier. And this is the one where the lawyer had been involved in a representation of the client, had been helping the client in a piece of litigation, a real estate litigation, and then turned subsequently to entering into an oral joint venture to continue doing some real estate development with the client because they became friends, the client was happy, the lawyer was sophisticated and understood the real estate ins and outs, and so it was a natural partnership, so to speak. The lawyer had, in his mind, thought he was kind of moving on from the practice of law per se, more to doing kind of the practice of business with a client, but the lawyer was providing legal acumen. That's what the lawyer brought to the table in this joint venture, and so the result of that meant 3,300 applied. And so this is a not uncommon situation, and it's one that may be a little counterintuitive to you, the lawyer, who thinks you're moving from a pure attorney-client relationship to now a pure business-to-business relationship. And when you are with a pre-existing client or a former client and you're now providing legal services as part of the venture, you're going to find 3,300 potentially engrafting onto the situation every time. And so here again, use extreme caution. Follow 3,300 every time. Let's go now to example 5, which is sort of the flip side of the coin to example 4. Example 5 is the Fair v. Bakhtiari case we talked about earlier, where there's a joint venture with a client, but unlike it coming out of a relationship based in litigation, it comes out of a transactional relationship where the lawyer has been providing hourly transactional advice to the client and then trades that for a piece of the action in the venture, such that the client now doesn't have to pay legal fees on an ongoing basis, and they instead split profits. And that, again, handoff from traditional pure attorney-client hourly relationship to attorney-client joint venture relationship subjects you to 3,300 and the need to comply to 3,300, as we found in that Bakhtiari case where 3,300 wasn't complied with because of the writing requirement, and the lawyer was out of luck on his interest in the venture, along with being out of luck on even a quantum merit recovery. This brings us to example 6, which is stock, taking stock in your clients. This has become more and more common over the years as more and more startup businesses have demanded it. It's become part of the culture of the practice of law for corporate startup practices. And so lawyers find themselves having to, on occasion, in corporate representation practices for small startup companies, venture capital type businesses, needing to be in a position of being willing to take stock to even participate in the beauty pageant, so to speak, in order to get the work. And the general rule of thumb here is that if you take stock in a client in return for legal services, then yes, 3,300 applies because, again, if you go back to Rule 3,300, you are, and the language is, knowingly acquiring an ownership, possessory, or other pecuniary interest adverse to a client. You're taking stock in their business, and so you have to comply with 3,300. The ABA has actually issued a formal opinion letter on this. It's opinion letter 000-418 that walks through in great detail the applicability of the ABA rule, citing to the underlying state rules across myriad jurisdictions, California, New York, Illinois, Colorado, you name it, in terms of how this plays out and the need to be careful to make sure that you comply with this when you're taking stock. The horror story, of course, is the example of Passante versus McWilliam. This is a California Court of Appeal decision, and the facts are as follow. It's basically the story of the Upper Deck Baseball Trading Card Company. Upper Deck, as everyone now knows, is a massively successful baseball trading card company. But back in 1988, it was just an idea. Some guys had an idea to take holograms and put them on baseball cards, the same types of holograms used in currency and other security instruments. And they had been working on this with their corporate lawyer to try to get a deal done. They had reached the point that they had a deal pending with Major League Baseball, but they needed $100,000 of cash in order to fulfill some business obligations in order to be able to even get the deal with the Major League Baseball. And so they're in a pickle. They didn't have any money. The lawyer, the corporate lawyer helping them, mentioned this to one of his law partners, and the law partner said, hey, my brother-in-law is a rich doctor. Maybe he can give him a loan and they can get their money and then everything will be fine. The corporate lawyer talks to them. The company's thrilled about getting the loan. The company gets the loan of $100,000 from the lawyer's family or the lawyer's friend's family member. and the lawyer has now facilitated the loan. And the client says, thank you for doing this, I appreciate it. We're going to give you 3% of the company in stock. Lawyer says, great, keeps on representing the company and is thrilled to have 3% of this venture, which at that time, of course, was worth nothing. You fast forward a few years and it turns out the Upper Deck Trading Company is worth hundreds and hundreds of millions of dollars. And the lawyer then thinks he has 3% of a company that's worth a lot of money. They go to litigation because these relationships often turn sour. And in litigation, the lawyer actually goes to trial against the company when the company refused to honor the 3% deal. And the lawyer won and got a jury verdict of $33 million, representing 3% of the company. So you can see it's a very valuable company at that point. Unfortunately, though, the trial judge applied 300 and said the verdict has to be taken away because your entire deal for your 3% was a deal that's subject to 300. You didn't put it in writing and outline the terms of the deal in terms of how you're getting the $100,000 loan. You were going to continue to do the work, the pros and the cons, A to Z. And so therefore it's taken away. Lawyer appeals to the Court of Appeal, and the Court of Appeal affirmed, even noting that it seemed grossly unfair and really grossly sad. You could see in the language of the opinion that the court felt bad for the lawyer and felt that it was a brutally harsh result, but courts jealously guard these transactions and they demand complete, perfect compliance with 300. And so the Upper Deck case is the horror story for you as a lawyer, where you've invested a substantial amount of time for a client, they've given you some stock, the stock was worthless when you got it, but you spent a huge amount of time providing legal services, which legal services often are critical for the business to even exist and survive and get to the point that it can be monetized into value. Think especially patents that you may be getting for your client, for example, or negotiations of deals. And then you get locked out as the lawyer and you didn't comply with 300 and you're forever out of luck. It's a horror story. So the best advice here is that you must comply with 300. And the further wrinkle and complexity to the context of stock is that it's often hard to value the stock. And in order to assess whether it was fair and reasonable, you need some sense of, well, what is the stock worth and what's the lawyer providing? And so if there are documents that show what the stock is trading at in this illiquid market, maybe friends and family have invested or they've had a round of investment, you can point to that as being the sign of what the stock was worth, what you were giving, and why what you were giving was fair consideration for that. If it's truly indefinable, really financially, then what you really want to do, and this comes from the ABA opinion letter in terms of best advice to lawyers, is make sure that you memorialize in writing that the percentage agreed upon in terms of what the lawyer is getting is perceived by both the lawyer and critically the client as critical to the nature of this transaction, that the lawyer's services are critical for the client to take its idea and get it anywhere out of the gate. And so the success of the enterprise really hinges on the legal services that are being provided. You want to memorialize that so that down the road, if you spend 100 hours of work and you get $1 billion, you don't have someone saying it was grossly unfair, because who would give away $1 billion for 100 hours, right? You need to memorialize the nature of that uncertainty in the transaction and the critical nature of your legal services on the front end. Let's now turn to example 7, our next slide, which is loans. The rule here is simple. Loans to clients, or if you ever receive a loan from a client, they are subject to 300. The critical rule, especially if you ever find yourself in the position of asking a client for a loan, is that a failure to comply with 300 on a loan means that the loan can be rendered non-dischargeable in bankruptcy. This was learned in a case the hard way by a lawyer who received a loan from a client. Lawyer had financial trouble, went into bankruptcy and thought, like many loans, I'm going to discharge it in bankruptcy. And the bankruptcy judge said, well, while that's true for many loans that can be discharged in bankruptcy court, a loan from a client that didn't comply with 300 is not getting discharged in bankruptcy court. So, comply with 300. The side story here, in terms of the side rule that's very important with respect to loans, is if you as a lawyer meet with a client, you have a client, and you send the client off to some sort of financial institute or a broker to get a loan. so that the client can fund the litigation. That act of referring them to the broker doesn't subject you to 3300. In other words, you don't need to comply with 3300 and outline the pros and cons of getting a loan, in fact, to pay for legal services. If you simply say, I need money, you can go get a loan, go talk to your bank or whoever. But if you actually refer the person to a broker and then you as a lawyer maybe get some piece of the action by a referral fee or some other kind of consideration from the broker for referring this client to the broker, then 3300 attaches. And this is very important, if you send the client off to get financing, which is often common, so if you think as an intellectual property litigator, you have clients that come to you, they have patents that are worth a lot of money, they believe they want to litigate the patents, but it costs millions of dollars to get involved in extensive patent litigation. Client doesn't have the resources, and so your client may say to you, I need financing, and you may say, yep, there are financing vehicles out there designed to finance patent litigation. Here's 2 or 3 of them, go to them. Client goes off to them, and it's very complicated financing terms in terms of security interests in the patents and whatnot. And so the client comes back to you and says, yes, 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 I want to get all this money, which I'm going to use to pay you, the lawyer, in the litigation, but here's the deal that I'm being asked to enter with the financing company. Can you help me negotiate it? And you, the lawyer, say, sure, I'll help you negotiate it. Let's just get this sorted out so that we can get the financing so that you can have the money to pay me to litigate. Your act of being involved in the negotiation of that transaction subjects you to 3300 because you are now an interested party. Someone is taking an interest adverse to the client in terms of the financing deal. You're representing the client, and you need to be outlining to the client all the pros and cons of the transaction because you as a lawyer are actually interested in that transaction since it's one that's going to get you paid a lot of money in litigation. Example 8 is our final example, and that is the example of renegotiating fee agreements. So as we turn to the next slide, you can see here what we are talking about. We're talking about the situation where once a piece of litigation is underway, or substantially underway, the law presumes that all balance of bargaining power has now shifted to the lawyer. What I mean by that is as follows. The client, once litigation is underway, develops confidence in the attorney. And to get new litigation counsel up to speed can create delays. The lawyer now has a better understanding of the facts, exactly what they are, the law, what the nature of the judge, what's likely to come out in the case, and how it's going to shake out. And so because at this point, once a case is underway, the law concludes that the lawyer has superior knowledge and superior leverage. And so the courts regard the attorney now as a fiduciary to the client with respect to any post hoc negotiation or renegotiation of the previous fee agreement in any particular matter. And so this means the burden's on the lawyer to justify the fairness of any new agreement. The modern general rule, therefore, simply holds lawyers to a high standard. Based on the confidential nature of the attorney-client relationship and the potential for abuse or overreaching, belated or revised fee agreements are construed most strongly against the lawyer and in favor of the client. Some courts talk about this rule in terms of a presumption of invalidity, a presumption of fraud, or undue influence. Some courts even adjudicate the rule in terms of a lack of consideration. Regardless of how it's phrased, these agreements are presumed unenforceable unless the attorney proves otherwise and the governing ethical rule attaches to them. We can look at, for example, a case such as a case called Lossman from Illinois, and this is 274 Illinois Appellate Second at page 1 from 1995. And the case is as follows. Lawyers representing a client on an hourly basis for a real estate piece of litigation. Lawyer loses the case for the client, says I can take the appeal for you, but I need a flat $7,000 and I need a bonus if I win. Client says, okay, that's great. Lawyer says, but I also need a promissory note since you've now lost, we got a problem. Client says, that's not a problem, sure, let's do it. So, client signs a promissory note, deed of trust, lawyer takes the appeal, lawyer wins. Lawyer gets his appellate fee, his bonus, he's thrilled, he's getting all this money, but again, client then says no. Court of Appeals agrees with the client, and the Court of Appeals said, quote, An attorney fee contract entered into after the attorney has been retained requires a showing of clear and convincing evidence in order to rebut the presumption of undue influence. The court then went through the equivalent 3300 factors from Illinois and concluded that the lawyer did not disclose all relevant information to the clients, didn't give the clients an opportunity to seek independent counsel, that the clients could not be expected to understand the significance of an interest-bearing promissory note and those other terms, and therefore the deal was voidable at the client's election. And so the basic rule from this case and all the cases is that if you ever renegotiate a fee agreement with a client after the fact, once the case is underway, and you get any kind of security interest in the client's property, you absolutely have to comply with 3300. You'll be stuck with a presumption of invalidity, or in some courts it's an assumption of undue influence or lack of consideration, and you, the lawyer, will find yourself well behind the 8 ball in those cases. Another case, and this shows how draconian the rule can seem and how even unfair it may seem, even if the lawyer doesn't do anything particularly improper, is the case of In re Kindy's estate. This is found at 310 Southern 2nd, 349. It's from the Florida Court of Appeals in 1975. And this case unfolded as follows. A wife's having marital difficulties. She hires an attorney on an hourly basis. The husband dies, and she says, "Can you now represent me in probate proceedings?" And the lawyer learns that the client had signed an antenuptial agreement and so had arguably forfeited all of her dower rights. Because that agreement significantly affected, obviously, the widow's position in terms of the probate proceeding, she said, "Can you change this from hourly to contingency? It's uncertain for me." The lawyer said, "Okay, fine, I'll take a contingent interest," knowing he had to get out from under this, antenuptial agreement. Now, the amendment's made, she agrees to the new contingency deal, and she was then had to, at some point in the state court, file her dower election. But before she filed that dower election, even though it was after they had a contingency agreement, the lawyer learned that the husband had actually destroyed the antenuptial agreement. So there was no antenuptial problem. This client was golden and solid, so to speak, in terms of getting her money. And the lawyer now was getting a huge amount of money, his contingent interest, without having to get out from under an agreement. The lawyer learned of this fact, but didn't tell the widow of this fact right away. Instead, he just settled the case, got her all her money, got his windfall. He's happy, she's happy, until she learns what had happened, at which point she's not happy, and it gets put before the Florida courts. And the Florida courts concluded that that contingent fee agreement was void under the rules of professional responsibility. The terms had not been fully outlined, and the lawyer, implicit in the opinion, the court concluded, the lawyer did nothing wrong, but the lawyer, when he learned this was now an easy case, should have apprised the widow of that fact before the time came for her to make her election, and should have given her the option, since he now had a windfall, so to speak, of an easy contingency award based on a mutual misunderstanding of a prior fact, should have given her the option to revert back to an hourly agreement. That's implicitly what that Florida court held. So that case underscores the critical importance that whenever you're amending a contingent fee agreement, an existing hourly fee agreement, the highest duty of the most important candor exists and attaches to a lawyer and really requires all facts that get given to the client so that the client can make an informed decision. That brings us now to the effect of violating 3300. The principles here are as follows. If you violate the ethical rule of 3300 or the comparable rule in New York or other jurisdictions, it's not automatically void by law. So your transaction is not just per se void. It's voidable at the client's election. That may be a small distinction without massive difference, because if a client elects to void it, you are in a seriously difficult position. The other key takeaway here is that you can lose even a quantum merit-based recovery for work done, even if it's indisputably successful work. So you don't have some position in equity that you can necessarily fall back on to essentially make yourself whole on your lost legal rights either. The third principle is that this can lead to state bar discipline. And there's a couple examples I'll give you. The first one is from Iowa, and this is a case, it's 533 Northwest 2nd, 532, where there was a suspended lawyer who had entered business dealings with a client, didn't follow the rule, state bar suspended him, court affirmed it. Comparable case out of Arizona, for example, and these are just similar cases that you can find anywhere. I just picked a couple for you. 147 Arizona 106. Again, another real estate deal. It seems real estate is central to much of these disciplinary proceedings, but client and lawyer engage in a transaction. The ethical rule isn't governed. State bar discipline follows for the lawyer. The fourth effect of violating these rules is that, along with the presumption of undue influence, you now have the downside of potentially a tort claim against you for breach of fiduciary duty. The different courts in the different jurisdictions hold that a violation of the ethical rule itself can constitute a breach of fiduciary duty and therefore be the predicate for a fiduciary duty claim by a client against you. So you now find yourself on the receiving end of not just a declaratory relief type action to void the transaction, but even perhaps a damages action. And as you can imagine, creative plaintiffs, contingency lawyers may well be able to sit down with an expert or with their client and come up with something that gives them more than voiding the transaction, but some damages theory that shows your failure to comply with 3300 actually damaged the client actively in some fashion and leads to tort damages against you, which would then have the specter of punitive damages. And so now you're a lawyer who not only is losing your transaction with your client, but you're potentially on the receiving end of a judgment against you for damages. On the next slide, you can see this is the key point, which comes from the Fair case, and that is that a violation of the rules of professional conduct subjects an attorney to disciplinary proceedings, but does not in itself provide a basis for civil liability. But the rules, together with statutes and general principles relating to other fiduciary relationships, all help define the duty component of the fiduciary duty which the attorney owes to his or her client. So that's the governing rule, and you need to be very, very careful so that you don't just have bar problems, that you don't have tort problems too. Now, of course, on the next slide, as you can see, a client still has to come up with a damages theory, and it's not always going to be the case, of course, that a violation of 3300 independently damaged the client in some way other than the effect of the transaction being voided, but you don't want to find out again. This brings us to the key tips today, and here are the 3 points. And these are really presented to you in an order of approach from being extremely conservative to being less conservative. So the first one is the extremely conservative approach. If you are extremely risk averse and very, very conservative when it comes to risk, my advice to you is don't ever enter any kind of a business transaction with a client of any kind whatsoever at any time, period, full stop, end of story. Have engagement agreements with clients, represent them in your transactional matters or your litigation matters. Never do any kind of a business with a client, no matter how lucrative it is. That's the safest way to avoid any risk and to avoid even being in the position of being challenged on something. Now, of course, you have every right to engage in a transaction with your client. So if you're willing to take risk, because there's obviously lucrative reasons to make money beyond selling your time as being a partner or joint venture or an investment with a client, then enter transactions with clients, and this is the next approach, which means you will enter a transaction and you will do so knowing that there's always some level of risk that even if you act perfectly and you comply with every rule, you may get hauled into court in some public forum and accused of something that you don't like. And that's just a risk we take as business people. And if you're willing to take it, then the advice is as follows. Make sure, force that client to retain independent counsel. Don't ever recommend the independent counsel. Negotiate in writing with that independent counsel before the client signs any deal documents, and have those deal documents note the existence of independent counsel and have the independent counsel actually sign that she provided independent counsel to the client regarding the subject matter of the transaction. That's my key advice. That comes from the cases, that comes from the experience of the litigation I shared with you and where I had represented in one of my litigations for a client, an attorney client whose transaction was challenged. And so the third point here are the practice pointer points in terms of the terms you actually want to put in the final deal documents so that you can guard off against any potential claim and that you can protect yourself against even the most creative or unbelievable litigation positions former clients could take. So you want to put in those final deal documents. The client had independent counsel, and remember in the beginning you've put in writing that they should get independent counsel, you've sent them to independent counsel, you've negotiated with independent counsel, but you put in the final documents the client in fact had independent counsel, secured it, consulted it, in fact consulted it, and what I recommend you putting in is this B, 3B. You, the lawyer, are relying on those representations that they secured independent counsel as their own counsel to advise them on the fairness of the deal. You're relying on that as a lawyer yourself in entering this transaction with the client. You do that so that you have a good fraud claim against the client down the road. If the client comes and tries to get out of it with some creative wiggling argument, you can turn around and have some counter leverage of fraud, which may help you substantially in terms of how you bring closure to litigation. For those of you who are litigators, you obviously understand what I'm talking about in terms of the leverage. And also, what I highly recommend is that you have that independent lawyer not just negotiate with you so that you have a written record of the negotiation, but you have that lawyer, you demand that the lawyer sign these deal documents in a way that's more than just approved as to form, which is a common signature block for the lawyers, but instead say, I am the independent counsel who have in fact advised the client on the fairness and reasonableness of the transaction and the transaction terms herein, so that the lawyer is attesting that the client indeed got advice on it. Whether the client listened to the advice or not is the client's own problem to take up with that lawyer down the road, but you at least can always point down the road in a subsequent litigation to the fact that you've dotted the I's and crossed the T's. The final point to add is to make sure that when you have the client sign that it received independent counsel and the lawyer says, yes, I gave independent counsel, you have no confusion as to who it was, especially where you have scenarios of single member LLCs where there could be an arguable distinction between the LLC operating through its president and the human being president wearing his I'm an individual hat, I'm not the CEO hat. You want to guard for that too in these signatures. So this is why we're so uber cautious. Courts are hyper strict, hyper vigilant in voiding these transactions. If they can, they will jealously look to undo these transactions. Again, remember, lawyer-client transactions where you take an interest really trigger the opposite presumptions of all normative American legal principles we're used to in our law of contracts, and they can be voided. The final two slides are flowcharts for you, and these are really flowcharts that you can use to think through and make sure you detail this stuff in a methodical step-by-step basis. The first one is the flowchart of what you do when you have independent counsel. You want to send a written letter informing the client of the need for independent counsel. Ask that client to have the lawyer contact you. Don't give a lawyer referral. Allow ample time for the client to find a lawyer and secure advice. In other words, make sure you allow enough time that this transaction doesn't have to unfold over the space of hours or even a couple of days, because that makes it very hard to show that you complied with 3300, which requires, as you remember, the client have reasonable time to consult a lawyer. So step one, then there should be new counsel. Now you have a negotiation with that new lawyer. My advice, do this by writing. So you want a written record. You'll obviously get on the phone at times, but memorialize everything in emails or letters if you still send letters memorializing discussions, but create a written record of the negotiations with the adverse lawyer so that down the road you can show you were really dealing with an independent lawyer who vigorously fought for that independent lawyer's client's rights. Keep those records. Be very, very specific all the while about who's representing who, whether it's kind of someone in their entity capacity or individual capacity, if such a distinction could be created and used against you. And then in those final deal documents, of course, Have them recite the key facts of independent counsel, ample time, everything I talked about on the last prior slides. And then preserve those records and save them. Save them for longer than you normally save records. Sometimes you may have document retention policies that are 3 years or 7 years. Keep these records really forever, I'd recommend, because at any point this transaction with the client could go on for 10, 20, 30 years. You could be subjected to a challenge at any time. Now, the final slide here is the flow chart of what to do if the client just won't get independent counsel. And you can't force them to get independent counsel, and you're still allowed to enter a transaction if they don't get independent counsel. But if they don't, here's what you do. Start with a written letter, of course, again. And then if the client refuses to get another lawyer, I would recommend that you have them sign an attestation that you've been asking them to, they've chosen not to, they're going to negotiate without one. Just get them to agree to that in writing somehow so it's very, very clear. Now, you now have to outline the pros and cons of the transaction, and you must do it in a way that's adverse to yourself. So you need to give every indulgence against entering this transaction, explain all the cons in their most gory detail to the client of the transaction. The pros to the client you may want to understate. You really need to do this in a way that is adverse to yourself in order to comply with 3300. Allow ample time for the client to digest this. Don't let it unfold over a few days. And I would again at that point advise go get independent counsel. Just keep advising along the way. Keep a written record just as if you were negotiating with an independent counsel. Do this in writing so there's a written record of what happened and how the negotiations unfolded. And then again, in the final deal documents, recite those key facts that were outlined in the prior slides for the document so that down the road you are as protected as possible. That is the conclusion of our ethics presentation on attorney-client transactions. As indicated, these can be boomerangs, they can be tripwires. You have to be very, very careful. My litigation experience representing lawyers and seeing this in litigation has led to this program. I hope you have found it beneficial. The views expressed herein are only mine, so hold only me accountable. Again, Peter Afrasiabi for 1LP. Thank you very much.